Okay, so I have this page. I have the Stroud Judicial Dictionary. I wrote the reference here. Sorry about the scrappy paper, but I copied this at the Supreme Court Law Library. It's just a dictionary that outlines when you have a term, like I've looked up. Oops, can you see that? Clean hands. It's a doctrine. So you might look up something, clean bill of lading or whatever it might be. You look it up and it will tell you judgments that have been made using that term. It's not always 100%. It might have been mentioned somewhere else, but not in that way or something like that, so it might not be in here. But this is not necessarily the meanings. This is the court case meanings, which is common law meanings nowadays, generally. So I looked up clean hands doctrine. It was under unclean hands, but that says to go to clean hands. I didn't show you that page, but it says, see if I can point to it. See that where those black brackets, it's got a year and then some initials. That's a journal. So that's the pages of where this is mentioned. So for an analysis of modern application of the equitable doctrine of the claimant must have clean hands, see, and that's a case. So you can see here. All right, so I have a copy of that case. I can't show you the whole thing because it is copyright, but I can show you the title and I can show you things in it. So here it is, Clean Hands in Derivative Actions, CLJ 2002. So you saw the reference. There's the reference up the top and there's the reference in the start of the journal, and it's into company law. But clean hands can also be applied in a lot of situations. You just have to think about where it might be applicable. But for this case, for this topic, they talked about that the equitable doctrine of clean hands is well established, and that's down here in a reference note, which I'll just, oh no, it's in the back page. So number 4, I'm going to do some reference back and forward here. So number 4 is there. Newcomb first, the phrase was first used in Fitzroy and Gwilym, and 1TR, that's another case per Lord Mansfield. Although there it was regarded as equivalent to the maxim, he who seeks equity must do equity, a principle which is now regarded as distinct. So they're two different principles or doctrines relating to future rather than past conduct. So the clean hands is more about coming to the thing without your own messy involvement in the situation. So the first case in which a clean hands doctrine is recognised as a distinct maxim in its own right is Doing v. Earl of, which you'll see, and that's in 1 Cox Equity, CAS 318. However, the origins of the clean hands concept can be seen in earlier cases. So there's a lot of information there. There's 1, 2, 3, 4 cases that they have then referred to. So you can see the Strouds lead you into further commentaries. This article is a commentary. I'll skip down. Like I said, I can't show you the whole thing. However, so here the concept of clean hands, as with all equitable maxims, should not be applied blindly and without reference to the facts of a given case. So it could be it could be that we use it wrongly if we don't pay attention to how we're using it, this concept of clean hands, the doctrine. It's a long-standing doctrine, and let me just see the reference 12. So just go back to that page. That's the reference page. Oops, there's 4 pages of references. So 12, here we go, 12 Van Gestel and Can, 1987 times, 7 August per May, LJ. That looks like a Lord Justice, May, and it's an article in the Times. So, yeah, and so this goes into sharp use of it, dishonesty, clean hands required of the minority shareholders in the derivatives. This is business-wise, but like I said, you can use it in different things. Let's see what else. I'm just going to turn away for a second. So here's another spot where it's used. So there was a divorce proceeding. The wife continued with proceedings when the issue came to light and the improper payment was taken into account in a lump sum awarded to the wife. So the man was doing some naughty stuff with the business or company. The wife tried to get it returned to her through the doctrine of clean hands. But what happened instead is she tried to get the money, but what was really going on, or sort of the added thing that was being considered, is that the man had the husband they were going through the matrimonial stuff. He had already factored in that half as a lump sum in the matrimonial proceedings. So she tried to get action as the minority shareholder, but it was actually taken into account. So Towers establishes that behaviour by the minority shareholder, which in the eyes of equity would render it unjust to allow a claim brought by the company at its instance to succeed, provides a defence to a minority shareholder's action. In practice, this means that equitable defences, which would have been open to defendants in an action brought by the minority shareholder personally, would also provide a defence to those defendants in a minority shareholder's action brought by him. I don't know. I'm not sure what that bit means, but it looks interesting. So they're 2 different things. So this is the author talking here, where it says, I think this is his opinion about things. The behaviour of the plaintiff in this case in accepting the lump sum payment and nevertheless going on to bring the derivative action was sufficient to render it inequitable to allow the claim to proceed. So it was already dealt with in the matrimonial case, therefore this case was kind of a little bit abusive practice. They probably didn't charge her in that way, but they would have just declined the thing. So you got to be careful, because if you don't come with clean hands and then you make an accusation, you're just going to look dumb in front of the court, and then it comes down in the court record. So we now have that as a court record. So this is the thing. All those people doing mistakes and using these equitable principles in the wrong way, you're causing problems for everybody who wants to then go and use that. Because it may come down to one day you do something and then I or anyone else will go in and to use that principle, and because you've abused it, the justice or the people in the courtroom might interpret it in such a way that we get struck out or we get reprimanded by the court or laughed out by the court. And we don't want that. We don't want to damage other people. Just let me turn away. I'm just going to look, see if there's anything else. So coming down here to 32. Sorry, it's not 32, I think it's 33. So much will depend on the interpretation of the courts. It is probable that the concept will be interpreted as including bad faith which exists between the shareholder personally and the wrongdoer. The mistaken application of the clean hand doctrine in the context of derivative action therefore seems likely to continue if the Law Commission's proposals are introduced. So this is talking about some Law Commission proposals. So they're saying we have to watch out for bad faith between people trying to do one over each other, or just are not quite clear in their thinking, and so they're just trying to do a second thing. So the two issues, should the company be allowed a claim against the wrongdoer, and should the shareholder be allowed to profit from their own wrongdoing? And this is a big issue in the Clean Hands Doctrine in general. This can be applied, by the way, in a personal thing. Even just because it says derivative actions, it's not just companies. It can be applied across to another area because it's got judicial commentary. So this one here, it says, so should the company be allowed to claim against the wrongdoer? But I'm more concerned about the second one. Should the shareholder be allowed to profit from their own wrongdoing? When you talk about anyone else who's a partner, and I won't say who they might be or anything, if they are profiting from their wrongdoing, that there may be a situation of the concept of clean hands, or because if they're doing something wrong and they're being paid in any way for doing the wrongdoing, they have not come with clean hands. It doesn't matter if they're just an agent, although who they're an agent for is responsible, but these become potentially, and this is my view, I'm not a lawyer, potentially they become something of a secondary participant, but the problem could be that they may be also primary participants with whoever they're the agent for. So you have to watch we don't have to. I suppose it would be to the people to present it correctly to the court, and it would be to the court to make a reasonable a judgment. I don't know what the word is, a reasonable process to include that thing. So the company can claim against the wrongdoer. As I said, this is a company article. I'm not going to read the whole thing. So here's another one down here. Rather than attempting to obtain a collateral benefit for him or herself alone, A is abusing the derivative action jurisdiction which exists to do justice to the company. So we're trying to bring actions, and sometimes people they want to have a collateral benefit from the situation instead of dealing with the situation. So this is in regard to company. So for example, if you're trying to bring a case with someone and you're trying to get this collateral benefit, you're going to skew up your results. Because what's going to happen is you're trying to address the issue, the wrongdoer, and it could be in anything. This is about clean hands, but it could be anything. If you're trying to deal with the wrongdoer in a certain way, and you're also trying to get a collateral benefit out of it for yourself, you could be abusing process. So you could come across as not having clean hands yourself. So you gotta be careful. So this is law, and this is how it is. So when you come into any court or any law, and I'm not a lawyer, I'm playing that right out. I'm not a lawyer. I could become one. I've even said to the court I might become a barrister, or I don't know at my age if it's really worth doing. But so trying to be a collateral beneficiary into something does not absolve you from being party to a criminal action. This is company stuff. This is about trying to claim money back from a claim, but it still applies. Okay, you can almost apply across a topic if you're reading enough, you can almost apply anything. Sorry, I'm not allowed to put the whole case, the whole article, as far as, I don't even know. I know I'm allowed to copy it. So let me skip to something else just as quickly. So here's another question. Should the shareholders be allowed to benefit from their own wrongdoing? This is a really good question. In this Towers case, let's see if I can find the reference. It's in there somewhere. So in Towers, the court was concerned that the shareholders bringing the derivative action had received and indeed retained illegal dividends in full knowledge of their illegality. And in Nurcombe, there's another article, the court felt that in this action the plaintiff is in effect saying, although I have shared with the first defendant his ill-gotten gains, I want the court to order that he should pay over to the company his share of them plus my share so that I can have a chance of getting some more because of my status as a shareholder. See, so you're like trying to benefit. Sorry, I can't hold everything stable for very long. Yeah, so that's another really interesting point. And I'll give you the other reference for 45. Where is it? Yeah, so there's another case to read. Yeah, so there's lots of things. I don't know what the precedence for each of these ones was, but it's only just that little bit left and I've gone through the article. But so this is the whole game with how they work, how it works really. So to the extent that circumstances have been suggested here in which a minority shareholder situation or actions may affect the decision to allow a derivative action brought by that particular shareholder to proceed, these do not spring from the Clean Hands Doctrine, but rather from the particular factual circumstances of the case, or from an entirely proper desire on the court's part to use the derivative action only where it is necessary to achieve justice for the company. So that's not talking about the opposite getting the outcome they want. It's not about putting the company first. It's about the management of the derivatives is in charge. The company is in charge of that. So the company is responsible to ensure that the shareholders get all the money. Now you can see if you're watching Locust and Honey, you will see he talks about the what was I going to say? I can't remember. He was talking about the shareholders to above certain entities, and I won't go into it. But this is an article. I'm not gonna fuss about. But this is an article. I'm just about to purge these papers and have them scanned into my computer instead of keeping physical copy for now. But in Locust and Honey, he's talking about shareholders. Now, shareholders are going to try and get the money, whatever it might be. Everybody wants something. Don't get mixed up. Okay, everybody wants something, and so with this doctrine of clean hands, I absolutely love this doctrine because when I'm in something and I know for sure and I have evidence that they do not have clean hands, I have a good mandamus and a good standing to say, I'm sorry, but I asked for this. These people did not assist me. They were complying with some sort of a foreign thing over my Commonwealth, over the place that I'm native to, over my Constitution or the King's Highway or whatever it might be. Could be anything. I've got counsel in my mind, but that's not the there's no limitation on that. It could be anything. I've asked for assistance. They did not assist me. They even have in their policy, I don't know, equal opportunity, whatever it might be, and I asked under those premises and they declined and they fined me. So you can't just come in with unclean hands and then try to argue a point and try to be collateral beneficiary. It just doesn't work that way. You have to do unto those as you would do for yourself. So would you want someone, dirty hands, to come and accuse you of something when they've already taken money from you for that, for example, or when they've already they've already had you through court for it. Or, you know, anything unfair like that. Would you like that? Because a lot of people going to the courts, they're trying to argue a $400 fine or whatever. Or might be even less, I don't know, whatever amount. But they have no standing for it. And sometimes they just don't have clean hands because they don't know what they're in. They don't know what they're in. So like a license or, I don't know, parking, trafficking. Go and watch some of that, some more of that Locust and Honey channel, because I mean, he's brilliant. I'm going to see if I can actually maybe repost some of his videos to my video so you can see them. But I don't even know if I have an audience. Maybe I do, 1 or 2 people. Anyway, so this is a really good case. You can go and look it up. I think I got it in the law library, but I think you can get this online. Easily accessible. The reason those little bits of the case is outlined is because I looked it up from the Strouds. And let's just return back to that. It just says here, clean hands. For analysis of the modern application of the equitable doctrine, that a claimant must have clean hands, see that. And so we've quickly gone through a little bit of that. I can't cover the whole article. As I said, it's got this little thing here. Doesn't mean I can't, but I'm not going to try and I'm not going to argue with them. They know more than I do. And so, no, I really appreciate it. Thank you to Thompson and Reuters for that. And thank you to the Strouds, Mr. Greenberg, for reproducing the Strouds. And I believe that is the most recent edition, which might be 2023. I think that's the most recent edition, and that's where this will be from. So grateful. And thank you to the Law Library for this little doctrine here. And just a reminder, I'm not a lawyer. I'm not putting my name up here. I'm not advertising or approving any abusive process, because I love the law. I have a long, strong history in the law in my family, and I would never allow, sorry about the word slips. I do have a disablement, so just bear that in mind. But I have a long family history in the law and in the military, and so I don't have an interest in messing about. Obviously not my immediate family, but my family in general and in the background. So my background is Lord Chief Justices and that sort of thing, and earls and all of that, as many of us white people, we'll call them white people, do have. I very much definitely have that history. I've looked in these books and I've read and found some of my family history in there, so which is quite interesting in itself. And so yeah, these doctrines are really important when you come into the court. If you don't know your stuff, I wish you luck. But if you get it wrong, and what's the worst that can happen? I don't know. But yeah, I really think you need to really think about things like that. Coming into the clean hands, into the court with clean hands, into the applications with clean hands, but also to prevent you abusing process, you need to come with enough knowledge, because any lawyer can walk in, they might know more than you, or they may just know something you don't know on that topic, and that'll be the end of your case. Okay, the courts don't always have time, they don't always make time for you to have a break and go and look it up. Although they try. Anyway, I can't give you everything. I just wanted to present this article and yeah, let you think about some of the things that I get into, that I read. I sit in the law library quite frequently. I should be a bit more open with the lawyers when they ask me about being there, because they know I'm there. And they say, you're always here. Why, you know, they don't ask me why I'm always here. They just say, you're always here. And I get the feeling they're asking for something and I'm not getting the communication or something. So maybe I should answer a bit more clearly as to why. But anyway, that's Stroud's, one of my favorite little places to look, and that's an article from there. So thank you very much, and I wish you to keep clean hands and to ensure that you know this doctrine, and that you know how to make sure the other people keep to this as well. And thank you to Ms. Payne for this article too. Thank you very much. Okay,